The Karnataka Advocate General told the High Court on Monday that the state has taken steps to ensure that officials from the state's education department do not act in an unacceptable manner with Muslim girl students while enforcing the court's interim order prohibiting religious symbols in colleges with dress codes until the case is resolved. Muslim females were being refused access by officials at various institutions, according to a memorandum provided by Mohammed Tahir, an advocate for petitioners against the hijab ban in a few government colleges in Udupi. Although the High Court's interim judgment of February 10 said that dress regulations may only be implemented in institutions where they have been mandated, it has been construed by the Department of Education and state officials as a blanket prohibition on religious apparel in universities. I've sent a letter to the Chief Secretary, requesting that he call a meeting of all parties involved. I've spoken with the Education Department's Senior Secretary, who has assured us that nothing untoward will happen. The Advocate General assured the High Court's entire bench that any actions taken would be notified to the court. The full bench of Chief Justice Ritu Rajawasti, Justice Krishna M. Dikshit, and Justice Jaibunisa M. Karsi is hearing a slew of petitions challenging the hijab ban, which sparked demonstrations throughout the state. On Monday, the entire bench debated whether it was necessary for the court to consider whether the hijab is an important religious practice and, if so, whether it falls within the basic right to freedom of religion. Are we obligated to go into all of these constitutional issues? Is it important for us to investigate these factors, whether it is an essential religious activity or if it constitutes a breach of Article 25? The Advocate General was questioned by Chief Justice Awasti. The issue of whether the hijab constitutes a basic right, according to Naudagai, lies at the heart of the court's arguments. You have maintained that the government decision, dated February 5 and establishing uniform standards for schools and colleges, is completely harmless, and that you did not issue any directive prohibiting the wearing of the hijab. Your position is that the state government has made no restrictions on hijab and that only the pre-university institutions' uniforms must be worn. What is your opinion on whether or not the hijab should be permitted in educational institutions? You don't have any concerns if institutions allow it? You must be absolutely clear about your position, the Chief Justice stated. If an institution decides to allow or restrict hijab, we will make a judgment when the case occurs, Nawagi said. As a matter of principle, the response is that the Karnataka Education Act's preamble itself tries to develop a secular mindset. According to him, the state's position is that religious aspects should not be incorporated into educational institutions. Nawagi stated that under Article 25 of the Constitution, hijab cannot be elevated to the status of a basic right. The petitioners have not provided any evidence to support their argument that wearing the hijab is a basic right since it is not an essential religious practice in Islam, he stated, saying that they had simply cited from the Quran to establish that wearing the hijab is a religious practice. In response to the petitioners' claims, the Advocate General said that they have sought ruling that every woman who practices Islam is obligated to wear the hijab. They want a declaration that may bind every Muslim woman. I'm not one to pass judgment, but I believe you, the petitioners, must have exercised caution and wisdom in seeking a declaration before a constitutional court that would bind not just petitioners but everyone, Nawagi said. While the state administration has based the argument on the requirement of vital religious practice, Justice Karsi questioned if it would extend to freedom of conscience as well. The judge's first involvement in the case is a significant line of inquiry on whether the right to wear a headscarf may be located outside the right to religious freedom. The way you express your conscience is religious practice. The question of fundamental religious practice does not come up in the context of freedom of conscience, the Attorney General remarked, stressing that the rights to religious freedom and freedom of conscience are reciprocal, subject to public order, morality, and health, as well as the other provisions of this chapter, Nawagi stated, referring to Article 25, all individuals are equally entitled to freedom of conscience and the right to freely profess, practice, and promote religion. The Supreme Court has developed the essential religious practice standard over time, according to the Advocate General, to safeguard only those practices that seem to be important to religious practice under Article 25. He claimed that the petitioner's argument breaches the court's standard, citing Supreme Court judgments from the 1950s. He argued that in order for a religious practice to be protected under Article 25, it must first be established as a religious practice, then as an essential religious practice, and finally, whether it has an impact on public order, health, or morality, as well as whether it conflicts with other fundamental rights. Petitioners have claimed the hijab to be a basic right without proving that it is an important religious practice in the current instance. If wearing a hijab isn't required, it isn't necessary, according to Nadagai.